What happens when the most powerful judge in America laughs at a congresswoman's fight for voting rights? You get silence. Then you get history. This isn't fiction. This is a true courtroom moment where a freshman congresswoman, armed, with nothing but truth and evidence, stood against the Supreme Court and changed the direction of the law. In this video, you'll witness how Jasmine Crockett turned a dismissive smirk into one of the most powerful reversals in modern constitutional history. Stay with us until the end. Because the moment she spoke those words, the room changed, the law shifted, and a nation listened. The Supreme Court chamber was silent, but the tension? You could feel it in your chest, the kind of tension that only builds when power meets principle, when a voice the system doesn't expect decides not just to speak, but to challenge. Congresswoman Jasmine Crockett stood at the podium, not as a lawyer, not as a legislator, but as a witness for truth. She wasn't supposed to shake the highest court in America. She was supposed to be ignored, dismissed, outranked, and for a moment, it looked like that would happen, because right in the middle of her argument, Chief Justice John Roberts laughed, yes, laughed. The most powerful judge in the United States chuckled during a discussion on voting rights. Dismissive, cold, smirking. And just like that, the air in the room changed. Legal scholars glanced around. Journalists leaned forward, even the other. Justices froze. Had the Chief Justice really just laughed at a sitting member of Congress? At a black woman defending the right to vote? At the idea that modern voter suppression still exists? What happened next? No one saw coming. In just 3 minutes, Jasmine Crockett would do something extraordinary. She would put away her notes. She would lock eyes with power, and she would speak a truth so sharp. It pierced through robes, traditions, and decades of denial. By the end of that day, the courtroom would not be the same. Neither would the law. This is not a story about courtroom, decorum. This is a story about courage, about how one woman's refusal to be dismissed turned a smirk into silence, turned doubt into precedent. So if you believe in the power of standing firm, in the face of power that mocks you, keep watching, because what Jasmine Crockett did that day will not just change how you see the Supreme Court, it will change how you see yourself. Before she ever stood before the Supreme Court, Jasmine Crockett stood in courtrooms across Texas, not in marble halls lined with press cameras, but in small county courts, dusty, forgotten places, where justice often depended more on politics than principles. She wasn't there for show, she was there for people, people who had been silenced, ignored, pushed to the margins of the system. Born and raised in St. Louis, Missouri, Jasmine learned early what it meant to fight for what's right. Her father was a postal worker, her mother a public school teacher. They didn't teach her ambition, they taught her service. You don't get to quit, her mom used to say. Not when you're standing for someone else. That message stuck. She earned her law degree from the University of Houston Law Center, and instead of chasing big law firm money, she chased justice. Her cases were not easy. They weren't glamorous, but they mattered. Voting rights violations, police brutality, discrimination in plain sight. Where other attorneys saw risk, Crockett saw responsibility. She didn't fight for headlines. She fought for humanity. One of her most notable early cases, defending elderly black voters turned away from the polls. Even though they'd voted in the same precinct for decades, she sat beside college students confused by voter ID requirements, rules written to confuse, not protect. This wasn't politics. It was personal. Her work in the courtroom caught attention, not from donors but from communities. People didn't just vote for her, they trusted her. She was elected to the Texas House of Representatives, and then to the United States Congress. Even in Washington, she didn't play by the usual rules. She didn't climb quietly. She asked hard questions. She came prepared. No flashy speeches, no viral stunts, just facts and fire. She brought her legal training with her, her courtroom instincts, her refusal to let intimidation silence truth. And when the Jefferson County case emerged, a case that threatened to gut voting protections across the country, Crockett didn't wait for someone else to speak. She stepped forward. she submitted an amicus brief, a friend of the court filing that brought lived experience into the legal record, not just legal theory, but legal reality. And when she was invited to present that argument before the justices, she knew exactly what she was walking into: a chamber full of legacy, a court skeptical of her claim, and a Chief Justice not used to being challenged. But she didn't come to be liked, she came to be heard, because for Jasmine Crockett, this wasn't about a career, it was about a calling. Jefferson County might sound like just another dot on the map, but what happened there could reshape democracy across the entire country. The law in question looked simple. It required voters to present a government-issued photo ID at polling places. It also reduced early voting days and eliminated Sunday voting. To some, these changes seemed minor, even reasonable. Supporters of the law claimed it was all about election integrity, stopping fraud, making sure every vote counts, they said. But beneath the surface, the truth told a very different story. Because Sunday voting, it wasn't just a convenience, it was tradition, especially in black communities. It was souls to the polls, churchgoers walking together to vote after Sunday service, and now that was gone. The law also allowed voter rolls to be purged. Without adequate notice, tens of thousands of voters erased. Without warning, most of them, from precincts that had voted heavily against the current county leadership. Coincidence or strategy? That's what the courts were being asked to decide. And as the case moved from local courts to federal appeals, the country began to watch. Lower courts were divided. Some said the law was discriminatory. Others said it was neutral on its face. So, the case climbed higher and landed in the hands of the United States Supreme Court. That's when things changed, because Jasmine Crockett entered the arena. Though she wasn't one of the lawyers bringing the case, she submitted an amicus brief, legal document offering additional insight. And given her background, she was invited to speak directly to the court. She didn't come as a partisan, she came as someone who had walked voters through broken systems, someone who knew the law and the loopholes people used to bend it. For her, this wasn't just about Jefferson County, it was about every county, every state, every voter being told, your vote is too complicated, your ID isn't good enough, your voice doesn't matter. She saw a pattern, a coordinated strategy, wrapped in legal language, but aimed at one thing: disenfranchisement, the C. Supreme Court would soon decide, not just the fate of one law, but the future of voting rights in America. And standing between that law and the Constitution was a freshman Congresswoman with a courtroom mind and a civil rights heart. The chamber was packed, not with tourists, but with people who understood the stakes: civil rights leaders, legal scholars, journalists, and citizens who knew. This case wasn't just about Jefferson County, it was about them. 9 justices sat high above, draped in black robes, eternally stoic. Or so it seemed. In the center sat Chief Justice John Roberts, calm, confident, familiar with being the smartest man in the room. Then Jasmine Crockett approached the podium. She wasn't nervous, she was ready. She had prepared for weeks, reviewed every ruling, anticipated every objection. Mr. Chief Justice, and may it please the court. Her voice clear, her tone measured, her argument precise. She began by laying out the facts. How the ID law disproportionately impacted minority communities. She cited the data. She quoted precedent. She connected the dots. At first, the justices listened quietly. Even the conservative ones took notes. But then, she drew a line. She compared modern voter ID laws to historical tactics once used to suppress black voters. It wasn't hyperbole. It was context. That's when the shift happened. Chief Justice Roberts interrupted. "Congresswoman," he said, "are you seriously comparing her photo ID requirement to Jim Crow laws?" The tone dismissive, almost mocking, and before she could answer, he continued, "This court has heard these arguments before, and the data simply doesn't support your position." Then it happened. The chuckle, short, but loud enough. A murmur ran through the gallery. Had he really just laughed? at a civil rights argument, at a sitting member of Congress, at evidence she hadn't even finished presenting. Crockett paused. She breathed. This wasn't in her notes, but this was the moment. She looked up at the bench, not with fear, but with fire. "Mr. Chief Justice," she began, "with deep respect for this court, I must address what just occurred." The room froze. When presented with evidence that citizens are being denied their right to vote. Laughter is never an appropriate response, not from any member of this court, and especially not from its highest authority. Gasps, shifts in seats. Eyes widened. Even Justice Sotomayor glanced at Roberts, her disapproval clear. Roberts tried to walk it back. "I wasn't laughing at disenfranchisement. I was responding to the historical comparison." Crockett didn't blink. "With respect, that distinction does nothing for the citizens being turned away today." She wasn't being emotional, she was being exact. And in that moment, the courtroom changed. The justices leaned forward. The journalists stopped scribbling. Because the real hearing had just begun. Crockett could have backed down. She could have softened her tone, played it safe. But she didn't come to the Supreme Court to play. She came to prove. And now she had the court's full attention. "I have precisely such evidence, Mr. Chief Justice," she said, "and with the court's permission, I would like to present it in detail." There was no more laughter, only silence. And the quiet shuffle of papers. She began with the numbers. In Jefferson County, black voter turnout had dropped by 27% after the new ID law was enacted. White turnout down just 3%. Then she turned to the voter purges. Over 50,000 names removed from the rolls, most of them from minority precincts. She didn't just give percentages. She gave names, neighborhoods, real people who showed up to vote and were told they no longer existed. Justice Thomas leaned in. "Correlation does not prove causation, Congresswoman." Crockett didn't flinch. "That would be true," she replied, "if we didn't have direct evidence of intent." Then she revealed the emails, internal memos from the Jefferson County Election Board. One read, "We need to minimize turnout in problematic areas." She paused. "Let the words settle." "Problematic," she repeated. That was their term for predominantly black districts. Then came the text messages between election officials, celebrating the elimination of Sunday voting. No more souls to the polls, problem solved. A murmur ran through the courtroom. This wasn't conjecture. This was confession. She wasn't done. Crockett held up another document, fresh from the Department of Justice. A statistical report, controlling for income, education, and transportation access, even with every variable adjusted. The racial disparity remained, 99% confidence level. That means the odds of these results being random, less than 1 in 100. Even Roberts was now listening, not as a skeptic, but as a jurist. Still, he pushed. "Even if the impact is unequal," he said, "the state has an interest in preventing fraud." Crockett nodded. She expected that. She reached for her final file. "This report," she said, "details every credible case of in-person voter fraud in Jefferson County. Over the past 20 years, she paused again, 14 cases, out of more than 1.5 million votes cast." She looked up. "For this," she said, "we're willing to disenfranchise tens of thousands?" Now the courtroom wasn't just silent. It was stunned, even Roberts no longer smiling because the facts had just taken the floor and the tide had turned. For 2 weeks the nation waited. News anchors replayed the hearing. Legal panels debated the evidence. Social media lit up with one question: would the Supreme Court actually change its mind? Then, the ruling came down. Jefferson County v. United States. In a 6-3 decision, the court struck down the key provisions of the voting law. And the most surprising part, the author of the majority opinion was Chief Justice John Roberts. The same man who had once laughed, now led the court in a new direction. In his written opinion, Roberts acknowledged a shift. He wrote, "While this court has previously emphasized that not every voting regulation requires strict scrutiny, we cannot ignore substantial evidence that certain provisions were designed to disproportionately burden the right to vote based on race." It was more than legal language. It was a reckoning. Roberts even went further. He stated voter suppression, like many forms of discrimination, adapts to legal constraints while maintaining its essential character. And in one breathtaking line, he admitted, "This court cannot and will not look away." The room where Crockett once stood in silence now echoed with the weight of those words. The decision set a new precedent. Lower courts were now required to investigate not just the language of voting laws, but the real-world impact, statistical disparities, internal communications, historical parallels. All of it now mattered. Justice Sotomayor, in a concurring opinion, explicitly credited the evidence presented during oral argument. She wrote, "The comparative analysis presented before this court provided exactly the kind of context needed to evaluate modern voting restrictions." And across the country, the dominoes began to fall. Civil rights groups filed lawsuits against similar laws in other states. Courts began re-examining cases they had once dismissed. State legislatures paused their proposals, suddenly aware that the ground had shifted. In Congress, a bipartisan group introduced the Equal Access to Voting Act. The bill mirrored much of what Crockett had argued. Federal minimum standards for early voting, clear guidelines on ID requirements, and protection against unjust voter roll purges. But beyond legislation, something bigger changed, the narrative. Because for years the story had been the same. Voter fraud justifies tighter laws. But now, the court had declared, the real threat wasn't fraud, it was disenfranchisement, and the voice that helped make that clear wasn't from a lifetime judge. It was from a freshman congresswoman who refused to stay silent. The ruling was out. The headlines were everywhere. But the real story was just beginning. Jasmine Crockett didn't just win a legal argument. She shifted the national conversation. CNN called her performance a masterclass in courtroom persuasion. MSNBC labeled it one of the most consequential oral arguments of the decade. Even outlets that had once ignored her were now reaching out for interviews. But Crockett, she didn't run toward the spotlight. She walked back to her office, answered emails, prepared for committee work, because for her, this wasn't about fame. It was about function. On the courthouse steps, civil rights leaders spoke with renewed hope. "We were bracing for another setback," Reverend William Barber said. But what we got was a turning point. The public noticed too. Voters from across the country flooded her inbox. Messages of gratitude, of inspiration, of awakening. One woman wrote, "I've never seen someone look the Supreme Court in the eye and say what needed to be said. Thank you for speaking for us." Law schools took note. Professors began teaching the Jefferson County hearing. As part of constitutional law curriculum, guest lectures were requested, panels were offered. Young lawyers wanted to know, how did she do it? Her answer: preparation and purpose. Even within Congress, the mood around her shifted. Colleagues who had barely noticed her before now sought her insight. Members from both sides of the aisle acknowledged her sharp mind, even if they didn't agree with her politics. She became a sought-after voice on voting rights, judicial accountability, and constitutional interpretation. But Crockett kept her focus. She returned to her district, held town halls, listened to the people who sent her there, because that courtroom victory was never about prestige. It was about principle. And while Washington buzzed, she stayed grounded. A reporter once asked, "Congresswoman, did you ever imagine this kind of impact?" She smiled. "I imagined fairness. I imagined truth getting its due. I just didn't expect it to happen so fast. And yet, it did. Because sometimes all it takes is one voice, prepared, grounded, and unafraid to say, 'This isn't right, that.' Voice can echo through institutions, change rulings, shift futures, and in this case, that voice belonged to Jasmine Crockett. It didn't start with power. It started with purpose. Jasmine Crockett didn't walk into the Supreme Court thinking she would rewrite legal history. She walked in with a folder of evidence, a fire in her chest, and a promise she made to her constituents to fight for their voice. And somehow that one voice shifted the foundation beneath the highest court in the land. It reminded us, democracy is not maintained by tradition, it's preserved by courage, because the right to vote is not just a policy debate. It's the root of every other right we have. When that root is poisoned, everything else begins to rot. Crockett didn't bring anger to that courtroom. She brought truth. She didn't attack the court. She challenged it to live up to its own ideals. And maybe that's the greatest kind of patriotism. Not blind loyalty, but principled insistence, the courage to look power in the eye and say, "You're better than this, you must be." And for once, power listened. The Supreme Court changed course, not because of noise, but because of clarity, not because of protest, but because of precision. And in that moment, Jasmine Crockett became more than a congresswoman. She became a reminder that your background doesn't have to match your surroundings to make a difference, that your rank doesn't define your reach, that, even if they laugh at your truth, you tell it anyway because sometimes the laugh fades. The facts remain, and justice finds its voice. One voice can turn a case, change a court, inspire a nation. One voice can make citizens believe again that the law still works, that truth still matters, that we are not powerless if we refuse to be silent. So if you've ever doubted that speaking up makes a difference, let this be your proof. Jasmine Crockett didn't shout. She didn't beg. She stood. She spoke. And she changed the story. That's what democracy needs. Not perfection, but participation. Not noise, but nerve. Not permission, but preparation. And most of all, it needs people who still believe that one voice still matters. They thought she came to lose, to be politely ignored, dismissed by experience, drowned by tradition. But she didn't come to play the game. She came to change the rules. Jasmine Crockett didn't just win a case. She exposed a truth, one the court could no longer deny. She reminded us, justice doesn't begin with institutions. It begins with people who refuse to look away. If you felt that in your chest, if your pulse quickened, if you remembered someone once laughing at your truth, then you know this wasn't just her moment, it's ours. So let's carry it forward. Speak up. Stand firm. Even if they roll their eyes, even if they smile and say, "You'll understand when you're older," even if the room falls silent. Because sometimes that silence means they just heard the truth. Louder than ever. If this story made you feel proud, angry, inspired, let us know in the comments. Share your voice, and remember, it only takes one voice to make power pause, to make justice move, to make history listen.